I'm Ben Meiselas, joined by Harry Litman of Talking Feds, the Talking Feds YouTube channel, the Talking Feds podcast. Subscribe to both right now. Harry, got to talk about Judge Aileen Cannon. Earlier in the week, she issued this. If you thought her equitable jurisdiction order from 2022 was something where she was the first judge in history to assert equitable jurisdiction over a search warrant, was overturned twice by the 11th Circuit Court of Appeals. Earlier this week, she ordered that special counsel Jack Smith has to disclose on the public docket the government's confidential witnesses, what's called Jenks material, the confidential reports, inculpatory reports that don't even ever get released until a witness actually testifies at the trial itself. She ordered that FBI code names be made public on the public docket, compromising other investigations. And she said that special counsel Jack Smith and your team, you did not show me that there was a compelling government interest in keeping this material under seal and confidential. Jack Smith responds. Jack Smith says, first off, Judge Cannon, you're applying the wrong legal standard. It's simply a good cause standard. Just because Donald Trump wants to file it on a public docket, it doesn't convert a good cause to seal standard into a compelling government interest. But even if you want to say it's a compelling government interest, Judge, manifest injustice. You're about to potentially kill people here. And let me show you some examples, if you don't believe me, that you may kill people by what it is that you're doing. Hint, hint, we're going to the 11th Circuit, and you're so wrong here, there may be broader ramifications. What do you make of all of this? I mean, as someone who is a leader within the Department of Justice, have you seen anything like this ever?
Man, oh man, ever is a pretty big word, as I tell my kids, but she has really stepped in, and we've been waiting for it. Look, she comes into the case that already had everyone dreading what she could do, and proceeds to really whiff, importantly, twice. As you said, she took a regular search warrant and completely gummed it up and did what Trump wanted. But that's been significant because the question has been, maybe she is 2/3 of the way, 2 strikes on her to being recused. Now, the recusal standard in the 11th Circuit, it's pretty high. The main precedent that we know is when a judge basically refused to do what the 11th Circuit ordered. But this is getting pretty close, and she's now in a box. Just as you say, a routine motion where they have good cause. And this is really pretty basic. Good cause versus the highest standard, which is reserved for the First Amendment. And she just whiffs on it. Now, you very rarely bring motions for reconsideration, and even more rarely are they granted. But Smith's bringing it makes plain that this is an egregious mistake. And he had previously filed this week some information, as you're saying, that makes it clear you're going to get people killed. There's problems with, not just the integrity of the trial, but all kinds of things. There's apparently already, we learned from this, a criminal investigation going on because somebody in Camp Trump has somehow obstructed or tried to intimidate a witness. So here is where she now stands. She is very cleverly, I think, not exposed herself to really getting clobbered on appeal and having the possibility of recusal. So, for example, on her docket, the trial date is still listed for April 4th. That's a joke. It's fanciful. Everybody knows it. But the way it's happened is she granted all these extensions so that it could never be that the April 4th date would hold, but she's waiting to actually pull the trigger and say the obvious. Here, though, she can't back away. She has 2 choices, both bad. She either has to say, okay, I screwed up and pretty badly, egg on her face, grant a motion for reconsideration, or she's got to be ready to be brought up to the 11th Circuit. The DOJ doesn't bring these kinds of motions casually. And in this case in particular, they want to have their ducks in a row. But this is the closest. If she so blatantly messes this up, they might really say, okay, here we go, 11th Circuit. And by the way, when they wrote, oh, you've got the wrong standard, it's a completely clear proposition. They could have chosen anywhere, everywhere, 26 sites, just a single one. 11th Circuit. So, I mean, it really is a rattling of sabers. And she said right away, she was going to release them this morning. Instead, she said, okay, Trump, what's your answer to this? Oh, please tell me by February 23rd. So like another 2 weeks, just answer this and then we'll serve it up. And now what's she going to do? Will she, just swallow hard and say, yeah, I screwed up in something very basic? Or will she expose herself to a possible motion for recusal? I think she's got to do the first, but she has a way of trying to save face that in fact, there's a chance she sort of doubles down and then there'd be real drama in what would be a likely appeal.
She learned all the wrong lessons from the first time that she was overturned. The right lessons are you follow the law. The 11th Circuit is a conservative circuit, but not a MAGA circuit. And they are law and order. And when she applied a different standard for Trump than was applied historically on equitable jurisdiction, the 11th Circuit really kind of laughed and mocked and issued this scathing order. So you would think for a young judge, the message that you get is, let me try to come into conformity with my judicial peers and bosses at the 11th Circuit. Her lesson was, I think, and I'd love to get your take, I issued my ruling too soon and gave the DOJ an opportunity to then continue their prosecution. What I should have done was never actually issued a ruling that can get appealed and just keep issuing scheduling orders, perhaps in the equitable jurisdiction case where they had that, independent monitor kind of review the records. Like maybe we could have had that federal judge spend more time looking at documents, and I could have dragged this out for many, many years. So she's looking at that lesson and saying, she's both trying to keep a trial date. As you said, I think April was pre-trial. I think the date's technically May 20th when the trial is currently scheduled for. But she's like, let me keep this trial date on to try to block some of the other trials, but then let me not make any rulings on anything so I can't be appealed. Jack Smith kind of piecemeal, piece by piece by piece by piece, kind of arranging the chessboard here. And at some point, Judge Cannon's bluff gets called, and that's all happening right now, right? It's like, where do you maneuver? And that's where she's stuck. What do you make of that?
Yeah, boom, in real time. And this wasn't a little piecemeal. She just, left her queen unprotected. I think a couple things. First, you're right, it's not a MAGA court. It's a super conservative court, but I don't think it's a conservative liberal issue.
Exactly.
She's an embarrassment. She is an embarrassment. And I think the 11th Circuit would be happy if they had an easy excuse to get rid of her. And then second, intention. God, I hate to psychoanalyze judges and run too quickly to the notion that it's all based on party and corrupt, et cetera. But I'll just say this about her, and I don't know if I would say this about anyone else in the country, but there are a lot of actors out there, Roger Stone, whatever, who are conducting their lives on the hope, on the roll of the dice that, somehow Trump will win election and then everything will be groovy for them. And I think Judge Cannon's conduct is at least consistent. I don't want to go to the depths of her heart, but I mean, imagine if Trump wins, she's going like a bullet to the 11th Circuit, right? And if he doesn't, she's kind of, I think, labors in obscurity and as a bit of a laughing stock. So I'll just say that what she has done is consistent with that kind of craven calculation. That's already, I think, pretty damning. I'll leave it at that for 1 week.
Well, I think the great point that you make is that this is not a liberal conservative issue. This should be a safety issue, a law and order issue, a basic competence issue. And I think that the media does such a disservice when they put us into camps that this is progressive and liberal and this is conservative because it's this way. No, there's just a lot of lawlessness that is occurring, and law and order should transcend political parties. And we should be able to look at this and say, this is a DOJ, if there are DOJ criminal investigations, if there are confidential informants, if there's Jenks Act material, confidential discussions between the government and witnesses that are inculpatory, there's a huge body of case law that talks about how this is dealt with, and then a judge comes along and goes, yeah, whatever, I don't care. Disclose it. Put it on the public docket. Make it because you haven't showed me, Jack Smith, that there was a compelling government interest. And Jack Smith's like, I haven't showed you there's a compelling government interest.
Right.
This is what the definition of compelling government interest is.
That's true. There's the manifest injustice part. But even before, it's actually good cause, Your Honor. Yeah. It's all the media, though, huh? We've met the enemy, and they are us.
Well, I think that when it is us, where we could reflect on is how these conversations take place, how we can improve them, and how we can learn from the lessons of the past. And what I love about the Talking Feds YouTube channel, and what I love about your commentary, but on Talking Feds YouTube, you get to do it in more detail and more depth like we're doing it here. We get to really spend time. We know that our audiences are smart. They don't want to be treated the way other media treats them sometimes. So let's just go through the facts, the data. They can make their decisions. And to me, it is about law and order. It's why that's why you and I went to law school. It's why you were a prosecutor. I mean, that's what it's about. Final words, Harry.
Yeah. No, go ahead.
Final words.
Oh, final words from me. Just step back, man. It is, we've begun to think we're in an era of general accountability. Maybe he's being brought to heel somewhat, but like the next week, before you and I will have our next fireside chat and warm encounter, that is a fireside behind you, isn't it, Ben?
It's a fireside. These are all fireside chats. That was the subtle motif here.
Before we will. He will find out, we'll know a lot more about immunity, which means we might know a lot more about immunity. And that's the one really case that if things go okay, comes at him like a freight train. And he might have been ordered to, write a $250 million check, both on the money and brand side of Trump and the stay out of jail liberty side of Trump. He's got a hellish week coming.
Well, we'll leave it at that.
Harry
Litman, Talking Feds. I'm Ben Meiselas. Help Talking Feds YouTube get to that 150,000 subscriber mark, and also subscribe here as well. Have a good one, everybody.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.